Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights attorney Nicholas D. Krawec discusses pretrial discovery.
Pretrial discovery, as the name would entail, being pretrial, becomes an issue when you are in contested litigation. The defendant has filed an answer, maybe some affirmative defenses and a counterclaim. And as the plaintiff who has brought the lawsuit and who is possibly the target of the counterclaim, you want as much information as possible about the allegations that are made in the defendant's defenses and in the counterclaim. Similarly, the defendant will want as much information as possible from you as the plaintiff regarding your evidence in support of your claim, the evidence that you have to rebut the defendant's affirmative defenses, and the evidence that you have in opposition to his counterclaim. Discovery, pretrial discovery, is essentially it's an information and evidence exchange. Each party gets information from the other so that there is no surprise or ambush at trial. But also, and this is very important from a creditor's perspective, if an answer is like a general denial or a demand for proof or something that is really a effort to buy time or a stall, if you will, pretrial discovery can be used in order to set the case up for a motion for summary judgment. And summary judgment, again, is another topic that's going to be in our Legal Master Series. But talking about pretrial discovery, there are two types of pretrial discovery. There's written discovery, which is typically in the nature of requests for admissions, which each party asks the other to admit the validity and the truth of certain facts so as to minimize the issues for trial, to eliminate the need to having to prove those facts at trial. Interrogatories are pretty much open-ended questions in terms of what the party knows about the transaction and what information they have about transactions. And the request for production of documents, as the name would imply, is a request by the other party to see what documents you have in terms of documents you will use to prove your case or documents that you have to refute the defendant's defenses or the defendant's counterclaim. Documents can also be subpoenaed from a third person or a third party who is not a party to the litigation. Either party can do that if there's a third party who has knowledge and documentation that is relevant to the litigation that's going on. The other type of pretrial discovery would be depositions, and that's oral testimony before a court reporter at the attorney's office under oath. It's convened by a notice of deposition to a party to the case, or a non-party to the case can be subpoenaed to testify as a fact witness. As far as the standard for discovery in terms of what can be inquired into, it's not so much whether something is going to be admissible at trial. The areas that can be inquired into in discovery is whether or not the area asked about is reasonably calculated to lead to the discovery of evidence which would be admissible at trial. So there can be questions asked at depositions, hearsay can be elicited at depositions, and even though something that may not be admissible at trial, they could be admissible, or usually are admissible at a deposition, because you are seeking information that could lead to the discovery of admissible evidence. Pretrial discovery, obviously, is a two-way street, as I mentioned earlier. The defendant can take the plaintiff's deposition or the deposition of any representative of the plaintiff's company having knowledge of the facts that are in controversy. The deposition notice would be directed to a particular person in the plaintiff's organization, or the deposition notice can go to a corporate designee where they identify the areas of inquiry, and the party who is served with the notice can identify the person who would respond to that notice of deposition. So the opposing party can serve written discovery on you. It's a time-consuming process, but you are involved in helping the attorney respond to the written discovery, and there's a requirement of full disclosure except for anything that's protected by attorney-client privilege or attorney work product or trade secret or proprietary information. Otherwise, you've got to produce documents that you do have. There's no hiding of documents or saving them for trial because, as I said earlier, discovery is to prevent surprise or ambush at trial. Bottom line, As a matter is referred to the attorney for collection, you get into contested litigation, and discovery starts up, your involvement is not over. It may well increase, particularly when pretrial discovery starts. You're a partner in the litigation with your attorney, you're a partner in the discovery, and it's important that you participate fully to the maximum extent possible. Thank you.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.